I want to thank everyone for joining us on part three of our four-part series entitled Subrogation at a Glance, an Overview of Recovery. Today's session, we're going to be talking about collecting on non-performing judgments and how to enhance your bottom line. I'm Mike Doherty from the Philadelphia office of Weltman, Weinberg & Reese, and I'm joined here today by Cameron Dean.
Thank you, Mike. I am Cameron Dean of the Philadelphia office, and thank you everyone for joining us today. I hope this presentation is useful in helping you turn your non-performing judgments into assets that will benefit your company.
So why is the collection of non-performing judgments important? Well, it's mostly important by the fact that there's about $15 billion of uncollected subrogation judgments every year. That's not the total out there outstanding, it's every year. So that encompasses basically every area of subrogation from auto to motor vehicle. So the importance of this topic is we want to make sure that you have the ability to attempt to collect some of those outstanding judgments, which will ultimately enhance your bottom line. So what does that mean? Well, that means that you have to figure out a mechanism, a process to recover that money. And the challenge related to that is how do you do it? And I look out there and I see we got a good amount of people signed on. I see a lot of familiar names of folks who are very familiar with the subrogation world. And they're all very good subrogation professionals, attorneys, and they know their business. But at the end of the day, if you have a products liability case, are you going to hire a tax attorney to handle that matter for you? You're not. You're going to refer that matter to a products liability attorney. Very similar to a subrogation action. Once you obtain that judgment, it's no longer a subrogation matter, it's a collection matter. And you need to find an expert who's able to collect that judgment, who knows the ins and outs of collection law, which is completely different than subrogation. With that in mind, there's two principles you should keep in mind. Number one, you've already invested the vast amount of your money in obtaining the judgment with your court cost, your deposition cost, and everything else. So you're already into the case financially, and the vast amount of your investment is already there. Secondly, what we tell folks over and over again is collections is a sprint, is not a sprint, it's a marathon. You need to take your time, you need to look at all possible avenues of recovery. And that's what we're going to try and do here today to show you those different avenues of recovery. In that regard, this webinar is going to talk about demand letters, charging orders, a vast variety of different means to collect on that judgment. So I'm going to pass this over to Cam, who's now going to start going through some of those different collection techniques.
Thank you, Mike. The first technique that we wanted to discuss today are demand letters. When it comes to post-judgment collection, demand letters can often be quite ineffective. As you know, the defendant has already received numerous court notices. I'm sure he or she has received pre-suit demand letters before, and up until this point, they have been unresponsive. However, demand letters are still useful as they remind the defendant that the debt has not just gone away on its own. And this can be useful if you need to pursue any future litigation to actually turn that non-performing judgment into an asset, as we'll discuss further along. The next topic I wanted to discuss with you are judgment liens. Depending on your jurisdiction, it may be necessary to record a judgment lien after you've obtained a judgment against a defendant. In some jurisdictions, this does happen automatically. This is an important step because it opens the door to other collection actions and prioritizes your claim over other creditors that may sue that same defendant in the future. Judgment liens can also prompt payment, as the defendant may learn of the lien being attached against their real property, such as a house or land. And if they are looking to refinance their mortgage or potentially sell their home, it is something that will now be brought to their attention. It is important to know that many jurisdictions require judgment lien creditors to renew their liens after a certain period of time, a necessary step to ensure your priority in front of other creditors who may have a claim against that same defendant is maintained. Some additional information about judgment liens are that they are generally inexpensive, and in some jurisdictions, as I mentioned before, they are automatically obtained. Liens also give you the right to collect the judgment if the defendant sells assets or if those assets are subject to a forced transfer, such as eminent domain or foreclosure from another creditor. It may also allow you to foreclose on the property on your own, property owned by that defendant. However, your judgment lien will often be a lower priority for payment than other liens, such as a mortgage, or if that individual owes outstanding real estate taxes, for example, there could be other people in front of you in the line to collect upon that sale. The defendant could also just hold on to their property if it doesn't have any equity and it's not subject to other court action. They could just hold on to that property for years and make it very difficult to actually turn into a useful asset for you, which can obviously, as Michael said, make collection a long-term game, make it a marathon instead of a sprint. I will now turn it back to Mike for some additional options he wants to tell you about.
Thanks, Cam. Another one of the techniques we use is an examination in aid of execution. We are all very familiar with a deposition during the course of any sort of litigation. What an examination in aid of execution is, it's basically a deposition. It's a deposition that takes place to determine the financial condition of the person you have the judgment against. This is very valuable for a lot of reasons. Number one, you get the financial information concerning that person. You learn about banks, you learn about employment, you learn about assets. In addition, you're compelling the person to appear in your office to testify to this matter. So again, that is an inconvenience to the defendant that will oftentimes generate a contact, and that contact often generates the ability to talk about some sort of settlement. Another mechanism we use is a wage garnishment. Now, a wage garnishment is probably one of the most effective means to collect on a judgment. And again, when we talk about a subrogation attorney versus a collection attorney, this is a great aspect. We know that wage garnishments are extremely important and effective in collection. But how do you determine where a person works? This is some of the information that when you're part of a collection firm, you have the resources and the abilities to develop a lot of information concerning that person from third-party providers, from your collection agents, from other folks who have the knowledge and ability to look for this type of information. In a typical subrogation case, this is not something you're looking for. This is something that the uniqueness of a collection attorney is able to find, because once you're able to get that information as to where that person is employed, you're then going to be able to attach their wages. Each state's a little bit different, so you'll be able to collect a different amount, a percentage of their wage, depending upon the jurisdiction you're in. And as you'll see, there's definitely some pros and cons to this, mostly related to exemptions for wages, who you can attach, how much you can attach. But at the end of the day, once you're able to develop that wage information, where they're employed, it's a great tool to be able to collect on a judgment. Another one of our great tools is a bank attachment. And again, a bank attachment, it gives you the ability to actually go into that person's bank account and freeze any funds they have in there. So obviously you can see how effective this could be. But again, the most important part about a bank attachment is how do you find the bank? And that's where a collection firm comes in, and it separates itself from a subrogation firm. The ability to find that banking information then gives you that leverage to freeze that account. Also, the timing of the bank attachment is of extreme importance. Most folks might try and file a bank attachment during Christmas. We would say you don't want to do that. Why? Most people already spent all their money around Christmas time. You wait for tax season. That's when folks are getting their tax returns, and it's the best time to file an attachment. So a timing of an attachment is just as important as to actually finding the bank. Because at the end of the day, the bank attachment, you do have to pay a fee for the court for doing so. And in some jurisdictions, that fee is more substantive than others. Also, you need to know the state you're in. Many states have very high exemption levels, where the attachment may not be worthwhile to even file. So it's important that you know your state, you know your exemptions, and you know your cost involved. Another great technique, the personal property levy. Personal property levy, what that basically means is you are able to attach the property of the person you have the judgment against. You are also able to take the property that a third party may have of your defendant and freeze that. Just to give you an example, think of insurance proceeds. I currently have about 100 cases where I have defendants who we have judgments against. And I'm reviewing court dockets in each and every court that they're in to see if they have a personal injury case pending. And there's probably about 100 of these personal injury cases pending. What happens is once this case would settle, I'm able to file a levy against the attorney for that defendant and obtain those settlement proceeds. It's amazing the amount of money that you're able to recover by just putting in the time and effort to look for these type of assets. Think of the dram shop case. Many times a client comes to us and says, well, I got this judgment against this bar, but the bar's out of business. What can I do? That liquor license has value. That liquor license gives us the ability to sell it through a levy, and we're then able to collect significant proceeds based upon the value of that liquor license. And that's the benefit of a personal property levy. So what you got to keep in mind is that a personal property levy can be expensive. So again, you need to know your court and you need to know your jurisdiction. Another unique aspect is called a charging order. Not all states have these. Basically, I describe a charging order, folks, as a wage garnishment for businesses. So what in effect does is, if you have a certain type of business, and the type of business does matter, whether it's an LLC or a limited partnership, you in effect get to step in the shoes of that limited partner. So all the subrogation folks will know exactly what that means, right? That's basically the concept of subrogation, the ability to step into the shoes of another. So you have a judgment against defendant A. Defendant A is a member of a limited liability company. At year end, he gets a distribution from that company. If you file a charging order, you step into the shoes of that limited partner, and that distribution goes to you. It's an incredibly effective tool to find funds from a limited partner within a business. Now, what you got to remember about a charging order, very state specific. So you got to know the rules. Not all states permit it, and it also relates to only certain types of business entities. The best part about a charging order is generally it's just done by motion. So it's really very, very cost effective, and you get a great bang for your buck. Another mechanism we talk about is the creditor's bill. And basically, to describe this one, it's basically a personal property levy on steroids. So when we talked about personal property levies, we talked about the ability to file exemptions and certain things that the defendant is able to exempt or keep free from the levy. A creditor's bill knocks out most of those exemptions. It's a very, very effective tool. The downside of a creditor's bill, it is a very complex procedure. It's very costly. So you need to make sure you're using it only in the appropriate case with the appropriate balance and also in the appropriate jurisdiction, which makes sense to use it. So I'm going to flip it back to Cam, who's going to take us through to the end here.
Thank you, Mike. And as Mike has been saying throughout this, and I believe a prevailing theme to keep in mind here is that your subrogation attorney is not always going to be best positioned or most knowledgeable to handle the collections. And I believe what I'm about to talk about is a great example of this. Say, for example, your subrogation attorney obtains a judgment, and then a week later, they advise you that that defendant has apparently transferred their vacation home at the beach to their son-in-law. And you say, what can we do about this? And that subrogation attorney throws her hands up and says, well, I don't know. This is where a really good collection attorney would come in, because what I just described is something that would consist of a fraudulent conveyance, potentially. A fraudulent conveyance occurs when a defendant sells or transfers property, usually to an insider, such as a friend or family member, but does not receive full fair market value in exchange for that property. And they do so intending to keep that property protected or away from creditors who are trying to attach to it. The transfer must occur within a certain period of time of that defendant either incurring that debt or intending to incur that particular debt. And this is something that is very state specific and would require you to know your jurisdiction that you're practicing in, to understand the time constraints and any other factors to define a fraudulent conveyance. But if you believe a defendant may have engaged in a fraudulent conveyance to circumvent your collection efforts, your next step would be to petition the court to get an order setting aside that transfer. that essentially will be putting the property back into the name of your defendant and then allowing you to take the various steps that we've discussed so far to try and collect from that asset that the defendant has. Generally, you would need to prove for a fraudulent conveyance, you need to prove that the defendant intended the transfer to protect their property from your hands, essentially. These are the factors that you need to keep in mind when you're trying to prove this. An insider is usually someone like a close friend or family member and generally has intimate knowledge about the defendant's financial situation and understands the purpose of this transfer, in that it's to hinder a creditor's ability to collect. If the defendant gives their house to their kids for $1 the day after you obtain the judgment, there's a very strong possibility this would be considered a fraudulent transfer. If the defendant has other assets that you could attach your lien to, however, then the transfer may not be considered fraudulent because you're not in a worse position under those circumstances. In order for a transfer of property to be a fraudulent conveyance, it really has to leave the defendant insolvent if they were not already insolvent. It also has to be made close in time to the incurring a debt or with the defendant's intent to incur a debt. And in the subrogation world, that's a little tricky. Generally speaking, most people do not intend to be the defendant of a subrogation action, as it usually involves some sort of accident or loss that is unexpected and unintentional. However, you would want to be looking at any major transfers that defendant makes since the time that the cause of action really arose, since the incident took place. The process of petitioning the court to set aside a property transfer due to a fraudulent conveyance does involve further litigation. Keep in mind that these are actions oftentimes filed against the third party, the recipient of that property, and not your original defendant. As a result, as you can imagine, specifically, the party does not want to just give back the property and say, oh, well, I shouldn't have taken this great deal. Instead, they would want to contest that and argue that they are a bona fide purchaser. So obviously, additional costs can come as a result of this. However, the potential benefit of recovering that asset and having it as a piece of property you can now cease to collect on your judgment may be beneficial if the case warrants it. The next thing we're going to talk about that you need to be aware of at this point as a post-judgment is bankruptcy. At this point in time, you're a creditor, and like any other creditor, you really need to be aware of how bankruptcy can impact your ability to collect. During your, if a defendant were to file a bankruptcy, it doesn't necessarily mean you're done trying to collect on your judgment. Instead, it is important to know a little about the different types of bankruptcy a defendant may file and what steps you should take depending on that type of bankruptcy. But the first and most important thing to be aware of as a judgment creditor is the automatic stay that is imposed as soon as a defendant files a bankruptcy petition. Once you receive a notice of the bankruptcy, it is important to stop any action that attaches to property of the debtor, as that debtor's property is now what's called bankruptcy estate property. This means you must release any bank freezes or wage garnishments that we've talked about in the past, but also requires any pending litigation to be put on hold. One thing that does not occur right away, or that you don't have to deal with right away, is lifting any potential license suspension if you're dealing with a motor vehicle accident subrogation claim. If you imposed a license suspension on a defendant to try and move along the collection efforts on that claim, you don't have to lift that suspension upon receiving notice of a bankruptcy filing, because that license is not a piece of property. Instead, it's a driving privilege, as most states define it. To be a little more specific, as to a Chapter 7 bankruptcy case, the collection may have to come to an end in these instances. Unfortunately, most consumers who file a Chapter 7 bankruptcy are doing so with what's called a no asset bankruptcy case. This essentially means that the debtor doesn't have any assets, any real property or personal property that a bankruptcy court could liquidate for the benefit of creditors, including you. Occasionally, a defendant may do a Chapter 7 bankruptcy where they have assets. When that happens, the Chapter 7 trustee in the case will send you and all the other creditors a notice that this is being converted to an asset case. And at that point, you need to file what's called a proof of claim. This is a document that our attorneys are very familiar with and know how to complete to make sure they are accurate and comply with bankruptcy law. That is a document that you would need to file, and essentially from that point forward, the bankruptcy court will do its thing. They will liquidate those assets through an auction process, They will build up a pool of money to then be distributed to creditors. And so long as you have a valid, timely proof of claim filed in an asset Chapter 7 case, you may be able to recover at least some portion of your judgment debt. In Chapter 13 cases, a debtor is filing a Chapter 13 case because they either have too many assets that don't allow them to file a Chapter 7, or that they do not want to liquidate in a Chapter 7 bankruptcy, or they just make too much money. In this type of bankruptcy, it's a reorganization of debts, which allows the defendant to pay some portion, or some cases, all of their debt back over a 3 to 5 year payment plan. The amount that they ultimately pay back is dependent on those assets and income levels I was just discussing. Again, it would be necessary to file that proof of claim by the deadline provided in the notice of bankruptcy filing that you would receive. But it is also beneficial to review the defendant's Chapter 13 plan, which is a document the defendant would file with bankruptcy court that outlines how much they would like to be paying per month, and also outlines how much each creditor is going to be getting from that monthly payment. It is important, though, to review that plan, because you as a creditor have a potential objection to confirmation that you would want to file if that plan is not paying you a sufficient amount of money. Now, what is a sufficient amount of money? That is a bankruptcy law question, and that is something that we have bankruptcy attorneys here ready to address if that were to arise. But just generally speaking, because you're a judgment creditor, your claim should be treated as a secured claim if the defendant has any assets, and you want to ensure that the debtor's Chapter 13 plan, what they're proposing to pay you and everyone else over the course of 3 to 5 years, treats you as such. And having that secured claim be filed timely would put you in a better position than other unsecured creditors, such as credit cards or personal loans that the defendant may have. One of the last collection options that we wanted to discuss with you today is foreclosure. When you have a claim against a defendant that you know has assets, but the defendant is simply refusing to pay, foreclosure may be one of the next steps in your process. Generally speaking, foreclosure allows you to force the sale of real property owned by the defendant, meaning a house or land, and then you can collect the proceeds of that sale to recover as much of your claim as you can get. While this option is great in theory, in practice, you have to be aware of other liens against the property that may have priority over your claim, how much equity the defendant may have in property, and also the costs involved with foreclosing. In most jurisdictions, foreclosure sales are a public auction, and the winning bid is often far less than the fair market value of the property. So if you're foreclosing on a defendant's vacation house, for example, and they have a mortgage that is a lien that's prioritized ahead of you, that mortgage would likely have to be paid in full before you can collect a single penny from that auction sale. Other lien holders may also take action to prevent the foreclosure, so there would be a lot of pre-foreclosure research we would recommend taking under before you begin the process of foreclosing, because of all the potential issues that can arise during that process. In closing, I would just like to mention to stay tuned for our upcoming episodes. The 4th episode with attorney Jamie Hart and Kyle Michael of our office will be coming out on Thursday, July 28th. And in addition to that, to best determine what post-judgment collection efforts you can pursue to collect on your subrogation claims, you can always reach out to myself or Michael or any of the other subrogation and collection attorneys here at Weltman, Weinberg & Reese.